So by now, you probably read the news. It's everywhere about the recent NAR settlement. There's a flood of information about it. However, the news fails to mention the one single most important thing you need to know if you're a home buyer looking to buy a home here in the South Bay and beach cities of Los Angeles, or anywhere in California for that matter. And in this video, I'm going to go into detail about the most important thing, because if you don't understand this, and no, I'm not being dramatic here, but if you don't understand this concept, it could cost you tens of thousands of dollars or worse on the purchase of your next home. I'm Steve Enchin, your source for everything real estate here in the beach cities in South Bay, and today I'm going to introduce you to a very boring topic, but it's a topic that you absolutely must know and understand, especially in the context of this settlement and a flood of news and really misinformation out there. So we're going to talk about agency law. Does that sound exciting? Well, trust me, it's not, but you need to know and understand it. Now, first, nothing in this video should be construed as tax or legal advice. So, what is agency law? Well, let's get started by illustrating the main problem with all of this news about the NAR settlement. None of these so-called experts and pundits or reporters are bringing up agency law. And second, agency law and how it applies to real estate is different from state to state. So your experience here in California could be different from your experience in New York or Florida. Agency law is a set of legal principles and statutes that govern the roles and responsibilities of the parties to an agency contract. Specifically, a person performing services, the agent, on behalf of the person who is hiring the agent, called the principal. Now, the agent has a fiduciary duty to the principal. And agency law is really everywhere, not just in real estate. If you hire an attorney, a CPA, a travel agent, if you have investments managed by someone else, if you're in the entertainment industry or play professional sports, you have relationships with professionals that are governed by agency law. Now, fiduciary duties impose the highest standard of care, and real estate agents must be committed to meticulously fulfilling those obligations. Now, in real estate in California, agency law lists 6 specific fiduciary duties an agent must perform for their client. Stay with me, we're really going to get to the point here shortly, but they are obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Now, obedience means the agent must follow all lawful instructions within the scope of their agreement. And this is very important because, for example, a home seller can demand to know, and the listing agent may be obligated to disclose, or, well, more likely will voluntarily disclose, all known facts about an unrepresented home buyer, meaning a buyer without their own agent. And then the seller can direct their agent to use this information in a manner that solely benefits the seller to the disadvantage of the unrepresented buyer. So let's think about this for a moment with a specific example. You've read all of the news and opinions about the settlement, and hey, you decide you don't need your own agent. You don't need a buyer's agent, and you think it's easier to get a better deal if you just go directly to the listing agent. So what could go wrong here for you? How about this? The listing agent learns everything about you, your motivation to buy the home, any urgency, how interested you are, and through all of your financial data, how much you can afford to pay. And guess where all this information could end up? In the hands of the seller, who will absolutely now use all of that information to place themselves in control of the negotiation and extract the highest possible price and the best possible terms and conditions for the sale, benefiting themselves at your expense. How could this happen? Well, it's based on how agency relationships are created. You see, the listing agent and the home seller have a written agreement that establishes their agency relationship and does so in detail. Everything including how real estate agents are compensated, is contained in that listing agreement. And you as the buyer do not have access to that agreement. You're not a party to it. You don't get to see it. And the contents are actually none of your business. Now, when you as a home buyer approach the listing agent directly, because you don't want your own buyer's agent, do you have an agency relationship with the listing agent? Well, it's actually a little complicated because California does what most other states have long ago declared was illegal. California permits dual agency, where the same real estate broker can represent both buyer and seller at the same time. Does this sound ridiculous? Yes, it's absolutely ridiculous. It doesn't make any sense. If you are in a car accident and were sued by the other driver, would you hire the plaintiff's attorney to defend you? Of course not. Not only does that sound ridiculous, it's not even legal or possible. Yet California still allows the same concept to happen in real estate, and this can set up home buyers for a very upsetting experience. Now, the home buyer, that's you, does not have a written agreement with the listing agent yet. Only the seller does. So while you technically have an agency relationship due to dual agency being legal, you're considered a customer, not a client, until you actually make an offer on that property and sign the dual agency disclosure and acceptance. And for that reason, your relationship isn't yet the equivalent of the home seller's relationship with that agent. The listing agent only really owes you the duties of transparency and fair dealing until you go under contract and create that agency relationship that is legally equivalent with the seller. Now, in all honesty, the listing agent should treat your personal information confidentially and facilitate a fair, even-handed transaction. But in reality, this isn't practical when the seller is really in charge, or the listing agent and then seller learn about your confidential details before you make an offer and accept dual agency. Now, California law specifically requires the listing agent in a dual agency transaction to keep all confidential information confidential. But in the real world, that just doesn't happen as expected. And for this reason, dual agency transactions have the highest incident of lawsuits being filed between buyer, seller, and the listing agent. The other issue is when an agency relationship is created between you and the listing agent, it isn't necessarily when you first start talking to the agent, and that is where you might make disclosures of confidential information to the listing agent that may be shared. So it's for this reason that I always tell my clients that if you go to an open house without me, never, ever talk to the listing agent. Don't even give them your name. You keep your confidential information private and never share it. Also consider what I told you a few minutes ago. Remember that listing agreement where it contains the compensation being paid to the real estate broker? The listing agent is being paid by the seller to help them achieve the highest possible selling price with terms and conditions most favorable to the seller at the expense of the buyer. That is the nature of the normal adversarial relationship between a home buyer and seller. So, with this in mind, do you think that the listing agent is going to invest hours of time helping you read through and understand the inspection report, or help you understand the mandatory seller disclosures and what they mean? Is that listing agent going to place the deal at risk by working with you to write repair requests that demand the seller make repairs or offer other concessions? Or will that listing agent actively manage your contingencies? Well, guess what? They really won't. What they will be doing is most likely steering you towards closing as quickly as possible at the sales price the seller feels is the highest they can get from you. And because you're not represented by your own independent agent, you have little insight into any of these details. You have no idea what's going on in the background. So now, are you starting to understand why going directly to the listing agent may be a problem? Does it still sound easier to you, and do you still think you'll get a better deal by doing so? So my brother-in-law is just like this. He tells me that going directly to the listing agent is just easier. And I've asked him multiple times to explain what that actually means. What does being easier mean? Yet I've never been able to get a clear answer from him on how or why going directly to the listing agent makes it easier for the buyer, or even why he thinks this way, especially given how agency law works and how buyers and sellers are represented in the reality of dual agency transactions. Now, can you just forego a buyer's agent and go direct to the listing agent? Sure. If you're comfortable negotiating with an experienced professional on the selling side, are familiar with contracts and the law, understand escrow and the title process, have relationships with licensed and experienced inspectors and contractors, know the local code and zoning requirements, can manage the documents, appraisal, mortgage lending, and have access or knowledge of off-market listings not in the MLS, then you bet. As another piece of information to illustrate how dual agency could be so problematic involves my own specialization in divorce real estate. With the special ethical requirements of this type of practice, the ethical guidelines within our trade actually prohibit us from accepting dual agency transactions. So on my divorce listings, I will require you as the buyer to go out and hire your own buyer's agent from a different broker. And that's how important fiduciary duty is, and how even the suggestion of or opportunity for any impropriety is absolutely prohibited for us. So even outside of divorce real estate, as a home buyer, would the suggestion of or opportunity for impropriety on the part of the listing agent be concerning to you? Well, so this weekend I read a ridiculous statement from the CEO of Redfin, where he was ecstatic about the opportunity to sell homes directly to consumers. It's an absolutely ridiculous statement because it completely ignores agency law and its importance, and it ignores that dual agency is illegal in much of the country. So where dual agency is not legal, what happens is the real estate broker no longer has an agency relationship with either party. And now the seller loses their protection under agency law. And a good example is Florida, where the real estate broker now just becomes someone to transact paperwork and no longer has a fiduciary responsibility to either buyer or seller. So how is this good for consumers? It's not. And in California, it takes an already problematic issue and just makes it worse by further ignoring the importance of agency law and trying to turn homes into consumer products you can just sell online. It's an absolute disaster waiting to happen. Now, personally, I believe one of the results of this settlement will be the elimination down the road of dual agency in California. So it won't be legal for one broker to represent both buyer and seller. And when that happens, every home buyer will need to hire their own buyer's agent. But for now, I just want to leave you with a few things to think about and consider before you come to the conclusion that now you don't need a buyer's agent or going to the listing agent is okay. So I would love to hear your own thoughts on this issue. So please comment below, ask questions. My contact information is right here on the screen, actually right there. And you can reach out anytime with questions about this issue or about moving to the Los Angeles, South Bay, and Beach cities. Oh, I also want to point out one additional fact that is of interest to home sellers here in our community. Unlike many other states who have different documents and procedures, here in California, as you would see in a listing agreement, the seller has always had both the right and the obligation to decide for themselves how to compensate or incentivize buyer's agents to showcase their home. You actually need to sign off on and accept any compensation to be paid to a buyer's agent and have always had the right to set that amount at whatever you feel is appropriate or even refuse to pay anything at all. So this entire lawsuit was never relevant to home sellers in California unless they work with unethical real estate agents who who insisted on a fixed amount for buyer's agents, or who told sellers they did not have the right to modify or choose their own buyer's agent compensation amount. So please be an informed consumer and make sure you're reading the documents that you sign, no matter if you're the seller or the buyer of real estate. This is so important. The state has a library of standardized forms and disclosures that have been tested in court for decades, and these documents are there to protect you. So I hope this video has been helpful and informative, and as promised, I'm not taking any position on whether the settlement or any possible future changes on how homes are bought or sold are good or bad. I don't want to debate the settlement. It is what it is. But the main focus of this video is making sure that you, as a home buyer and consumer, are completely aware of how agency law works in California, how it applies to you, and the key risks you face and have always faced if you decide to work directly with a listing agent and forego your own representation. That's it. Thank you for watching. We'll see you on the next video.